Welcome to our company law class. So having already discussed shares and share capital as part of discussion of corporate finance, we will proceed straight away to discuss another aspect of corporate finance, debentures and debenture stock. So just before we look at the law, you will recall that when we were discussing various sources of funds available to the incorporated company, we did mention also that the company can borrow. The company can borrow money, and when the company has borrowed money and same is evidence in writing, that becomes part of what we call debentures or debenture stock, as the case may be. But the Companies Act itself has given a particular definition of what a debenture is. So anytime you are dealing with the law, and the law has a definition of a particular concept you are working with, you must always have recourse to the statutory definition, because that is the true position of the law. So on that note, I invite you to jump to the first schedule, which is those who are using the printed copy, you have like the page 303. So debenture is explained in the following words. Let me open it here for you. So if you go to 303, this is how debentures are explained. It says debenture includes a written acknowledgement of indebtedness by a company in respect of a loan made or to be made to it or any other person or money deposited or to be deposited with the company or any other person, or the existing indebtedness of the company or any other person, whether constituting a charge on any of the assets of the company or not. So the first sense in which the word debenture is used or deployed in our Companies Act is written acknowledgement of indebtedness. So where there is a written acknowledgement by the company that it owes someone or has taken a loan from someone, or that someone has deposited money with it, that qualifies as a debenture according to the first sense in which it is used in the law. Debenture also includes B, debenture stock. Debenture stock, that is also another form of a debenture, and debenture stock simply refers to a block loan, as it were, in which different lenders have contributed, but for purposes of the company, it is reckoned as like a one, if you like, a huge loan. We will be looking at the specifics of it as we discuss Section 83 and the related provisions. It also includes convertible debenture. A convertible debenture is a debenture, a debt which can be turned into a share, so that the lender will no longer be a lender or creditor, but become like a shareholder. So that is a convertible debenture. It also includes a loan stock or an unsecured note or any other instrument executed, authenticated, issued, or created in consideration of such a loan or existing indebtedness. So all these are examples of debenture within the law. But the law excludes certain things which have the appearance of acknowledgement of indebtedness by the company. But for some good reasons, the law says that those are not to be treated as debentures. And what are those? Let me see if we can quickly exclude this so that you see it on the screen. So, good. So this is what I was quoting for you. Yeah, so if you look at it, the H said that, but does not, that is debentures does not include I, a bill of exchange. So from your commercial law or your banking law, you have come across like a bill of exchange. A bill of exchange is just a written note by someone saying that he owes or that a certain payment will be made to you. And then a promissory note also is also a form of a written acknowledgement of indebtedness, a promise to pay a certain amount of money in the future. Now, if you look at these two, for example, I've talked about, they are also written acknowledgement, but they are excluded from being treated as a debenture. The reason being that they are subject to different legal regime. So we have the Bill of Exchange Act, for example, which, as in Act 55, which governs matters relating to Bill of Exchange, promissory note, checks, and the rest. It also does not include a letter of credit. So where maybe a bank has issued the LOC, letters of credit, that payment will be made by them on behalf of a named person, that is also a form of acknowledgement of indebtedness, but is also excluded because it is subject to a different legal regime. In the same vein, an acknowledgement of indebtedness issued in the ordinary course of business for goods or services supplied is also not treated as debentures. So let's note this carefully. Goods might have been supplied to the company, services might have been rendered, and the company has given an invoice, which actually suggests that if the goods have been supplied, then the company owes the supplier or the provider by reason of that written acknowledgement. So ordinarily speaking, one would say that then that is also acknowledgement of indebtedness, and for that matter, it is also a debenture. No, it's not a debenture. The reason being that where goods have been supplied and they've not been paid for, we have a different legal regime. We have the Sale of Goods Act. The Sale of Goods Act, for example, will govern that. Where services have been rendered, like we have a general law of contract, or we have the Labor Act and other legislation as the circumstances warrant, which govern such arrangement. And that is why they are not included in debenture, despite the fact that they also have the essence of a written acknowledgement of what? Indebtedness. Again, debenture does not include a policy of insurance. If you have taken an insurance policy from an insurance company, you pay your premium and all that. In a sense, the insurance policy is a claim on the insurer, that is the insurance company, regarding a stated risk or harm when it does occur. Then whatever injuries or whatever losses arising therefrom, that will have to be met by the insurer. So on that note, one may say that it's also an acknowledgement of indebtedness, which may become due for payment in future should the stated risk or the stated insured harm occur. But the law says that it is not a debenture. Why? The simple reason is that insurance is also subject to a different legal regime. So you have the insurance law, you have the insurance act and all that. So that regulates insurance arrangement, and that is why it's not treated as a debenture. Again, debenture does not include a deposit certificate, passbook, or other similar document issued in connection with a deposit or current account at a bank, at a banking company. So where you have what do you call it, a debt with the, like you have a deposit to the bank, you've deposited money. In a sense, the money that you have deposited with the bank is a debt which the bank owes you, so long as you've not withdrawn it. Nevertheless, it is not treated as a debenture. And the explanation is that we have a separate legal regime which governs that. We have like the banking law. The banking law governs that. And that is why it's not treated as a debenture. So, for example, in examination, you could be told that debenture is a written acknowledgement of indebtedness by the company. However, not all such debts qualify as debenture. Discuss. So, giving you, I've not assured you, but it looks an interesting examination question. Debenture is a written acknowledgement of indebtedness by the company. However, not all such debts qualify as debenture. Discuss. We'll come back. Okay, so now that we've understood what a debenture is, we'll come back and look at the specific provisions relating to debentures within the law. So Section 831 makes the point that a company may raise a loan capital by the issue of a debenture or a series of debentures or of debenture stock. So now, as we have already noted, fundamentally, debenture is a debt. Of course, not ordinary debt, a debt which is acknowledged in writing, provided it is not those type of debts which have expressly been excluded by the law as not falling within the category of a debenture, as we have seen when we discuss the definition of a debenture in the interpretation section of Act 992. Let us also note that debentures of the same series shall rank at the same rate in all respects, although they may be issued on different dates. So if you have, for example, created a certain debt series, that we have maybe 5 million cedis debenture series or series of debenture, and within this 5 million, we have split it into maybe 10,000, 10,000, 10,000 cedis each. But altogether, they constitute that series of the debenture. Now, the point being made is that if you get 10,000 or 20,000 from such 5 million cedis series of debentures we have stated, even if yours was issued later than others. In terms of what the rights and the benefits are, you will still enjoy the same because yours fall within the same series. Now, it is also permissible for the company, instead of issuing multiple debentures, that is multiple written acknowledgement of debt representing separate debts which the company owes to those that are provided money. The company may decide to get loans that will be funded by the creation of a debenture stock of a prescribed amount, parts of which represented by the debenture stock certificates may be issued to separate holders. So it's essentially like the same idea related to the series of debentures, except that the debenture stock, you have like a huge loan, and you are going to give people who have contributed money towards that debenture stock, what we call the debenture stock certificates. And that could be given to the separate holders. Or you can even have like a trustee, right? You can create a trust as Section 83 for stipulate that debenture stock shall be created by deed under the common seal of the company or certified by signatures of the two directors and the company secretary in the form of a deed poll, or an indenture in favor of trustees for the debenture stockholders. So let's say that the company wants to raise a loan of, let's suppose, 10 million or 50 million Ghana cedis. And this 50 million Ghana cedis, the company may struggle to get one person who will contribute that money. So the company may probably get a number of creditors or lenders to come together and say that we are going to raise that for you. And maybe like in the ordinary business sense, they have what they call it the syndicated loans. So that is raised, and when it is raised, they can decide to appoint a trustee who will be responsible for managing the rights of those who contributed towards that huge loan that constitute the debenture stock. And another point to note, and which is quite fundamental, is that a debenture holder is not a member of the company. And let this thing sink in well. A debenture holder, unlike a shareholder, is not a member of the company. So Section 83(5) says that a debenture holder is not a member of the company, and despite a provision in a debenture or the constitution of the company, is not entitled to attend and vote at a general meeting of the company. So this is a statutory prescription. The law is saying that a debenture holder is not a member, and for that matter, a debenture holder does not enjoy the rights and privileges which are enjoyed by members of a company. And some of the primary rights enjoyed by debenture holder, enjoyed by members of the company are the right to attend and vote at general meeting. A debenture holder, as a rule, does not have the right to attend and vote at general meeting. It doesn't matter that when the company created the debenture, it inserted that clause in it that the debenture holder may attend in vote. Such a term will be null and void. In the same vein, if it's in the constitution of the company, to the extent that it allows the debenture holder to attend and vote at meetings of right, same will be null and void and of no effect. And that is the effect of section 83, subsection 5 of Act 992. So let us keep that in mind. It should also be noted that to create a debenture is contractual. It's a matter of contract between the company and the particular person who is going to provide the loan. For that matter, section 84 stipulates that a contract with the company to take up and pay for any debenture of the company may be enforced by an order for specific performance. You remember the equitable decree or equitable remedy of specific performance, by which a person is directed by a court of equity to carry out or to execute that which he undertook to do in a contract on the pain of being imprisoned or cited for contempt of court. Because as we know, equity acts on the conscience of the particular individual. So in appropriate cases, the court will direct you to carry out exactly what you undertook to do. And that is the effect of specific performance. Now that is also applicable to a contract to take up and pay for debenture. So let's suppose that the company has been engaging you. You signed the contract that, okay, you are going to take 10 million debenture created by the company. Having agreed, later on you have a change of mind and you don't want to go forward. The company can go to court and seek the remedy of specific performance against you. So someone may ask, why should the company be entitled to seek specific performance, or why should the person who entered the contract should be able to seek specific performance against the company? Because mind you, equitable remedies act on the principle of mutuality. It works in both ways. If it cannot be exercised by the other, then it will not be granted. So it's not only the company which can exercise specific performance. The prospective debenture holder could also seek specific performance against the company. So let's keep that in mind. And in my view, of course, we can hazard a number of business operational reasons why it is not fair if the company has spent time and has also probably restrained itself from taking some other loans and later on for you to disappoint it. In the same vein, where the company has actually gone far with you, and then for the company to also get like a change of mind, that is also not right. Now, how do we know that a person is a debenture holder? So we are going to talk about the documents of title to debentures. So just as we talk about share certificate, if you remember. So Section 85 provides that subject to the Central Securities Depository Act 2007, Act 733, a company shall within 2 months after the allotment of any of its debentures or after the registration of the transfer of any debentures, deliver to the registered holder of the debentures or a certificate of the debenture stock under the common seal of the company, or as certified by 2 directors and the company secretary of that company. So just like when it comes to share certificate, that the just as a person who has been issued with shares is supposed to get the share certificate within 2 months, and if the company does not do that, the person can even go to court and enforce it. The same idea is also applicable to debentures. And again, reference has been made to the Central Security Depository Act of 2007. So as we noted when we're discussing shares, that legislation, the CSD Act, Act 733, has created the regime of dematerialization of shares so that companies whose shares or securities, including debentures, are dealt in within the regime established under the Central Security Depository Act, they use delegates, rather than paper. So they have a paperless certification of ownership of debentures. So they are excluded. But apart from that, all other companies are supposed to issue debenture or debenture stock certificate within 2 months. And of course, where you have not handled it well, you can always request the company to reissue it for you after paying the prescribed fee. And that is the effect of Section 85(2). Of course, just as a failure or neglect by the company to issue a share certificate will entitle the shareholder to go to court, the same thing applies to the debenture holder in terms of Section 85(4). And if the debenture holder is pushed to go to court to get orders directed against the company for the company to issue the certificate, whatever expense or cost which the person will incur will be borne by the company and the officers involved. That is the officer who neglected to issue the certificate. What is the legal effect of statements or claims contained in the debenture stock certificate? Well, we also discussed the effect of a statement in a share certificate. So the same thing is applicable to debenture certificate mutatis mutandis. So if you look at Section 86(1), statements made in debentures or debenture stock certificates, including statements made electronically, are prima facie evidence, and mind you, is not conclusive, prima facie evidence of the title to the debentures of the person named in the statement as a registered holder and of the amounts so secured. So meaning that whatever is stated there, there's a presumption that it is accurate and that whoever is named there is presumed to be having title ownership of that debenture. But of course, that is a rebuttable presumption, and that is why the law says that it's a prima facie evidence. And just as we saw with respect to share certificate, if someone has changed his circumstances by relying on the statements in the debenture or debenture stock certificate in good faith and has incurred a loss, the company will be stopped from denying accuracy of the statements or the assertion in the certificate. And any loss which the person has suffered will be compensated for by the company. Of course, the company also has a right of indemnity against a particular officer whose negligence, or failure made the company get wrong statements in the debenture certificate, which has exposed the company to a loss, having to pay for the compensation. So the company can get indemnity, can be indemnified, or can also recoup its loss or expense, which is suffered by paying the compensation from the particular person whose neglect resulted in that situation. We'll now talk about types of debentures. But before we do that, I pause for a question regarding what we've discussed. If there's anything otherwise, I'll continue. Okay, there being no ones, we continue. So we have debenture, perpetual debentures, and perpetual debentures, as the name suggests, or some also call like the what do you call like the permanent debentures. Yeah, so Section 87 stipulates that a condition contained in a debenture or in a trust deed, remember, is the mechanism for creating the debenture stock, for securing any debentures shall not be invalid by reason of the fact that the debentures are by that condition made irredeemable or redeemable only on the happening of a contingency, however remote, or on the expiration of a period, however long. So the point about Section 87 with respect to perpetual debentures is that, yes, we know that debenture holders are not members of the company. And ordinarily speaking, they are not supposed to have a long stay in the company because they have lent money to the company. And then the money will be repaid or be redeemed in the foreseeable future. And then they will go. Now, that notwithstanding, it is permissible under the law for the company to structure the debenture in such a way that the debenture holder may even remain, have it no money by way of the debt, remain in the capital pool of the company for as long as probably the company even survive, or for as long period as one can imagine. And that may be attained by, for example, making redemption. If I say redemption, that is uh, the redemption, that is a repayment, right? Like when you repay the debt. In that case, the debenture has been redeemed, and that is it. So you can have a debenture which says that this debenture shall be redeemable. That is, the company will have to pay off the debenture holder, and the debenture holder will no longer have any creditor debt relationship with the company. When, for example, Ghana becomes maybe a developed economy with per capita income of $40,000. I'm sure I haven't checked the figures, but I'm sure our per capita income is still less than 10,000, and that's being the case, it will take really, really long time before our economy will grow up to the level of the really developed countries of having per capita income of $30,000, $40,000 per person. So that is really remote. and it may probably even never occur during the period that the company remains in operation. For that matter, a debenture is going to remain in the company for a long time. There's nothing wrong with that, and that is the point that Section 87 is saying. Or you can say that this debenture will become redeemable when the next kin, after the death of the current king Charles, when that person also dies before the debenture will be redeemable. King Charles is very much alive, and we hope and pray that he lives long. So when will he die for another to be, enthroned, and for that person to also die before the debenture will become redeemable? So that is the point. So that debenture will still be perpetual debenture because its redemption is contingent upon an event which may never occur or is remote. Yes, Nathaniel J. John? Nathaniel, yes, let's hear you.
Yeah. So if that is the case, then how profitable is it for one to invest in debentures? Because it looks like it will take forever for the person to redeem their capital. Thank you.
Okay, so the debenture being a loan has its return. Its return is the interest which we pay to the debenture holder. Just as the returns on shares are dividends when they are declared. So you have a loan that you have given the company or the company owes you, and there's an agreed interest rate exigible or payable at agreed intervals or periods of time. So the interest will be paid according to the terms of the debenture, as it were. But the principal, that is the debt which you paid, I mean the money you're giving to the company, which the company owes you as a debt, the principal itself is what may not be paid off until the stated contingency, which is really remote or may never even occur, has actually occurred. Yeah, so your returns for investing in a company by way of debentures is the interest rate. But of course, because you are going to put your money in the company as a lender, a debenture holder, you also do your feasibility studies, do your financial analysis for the performance of the company before you commit yourself. We also have convertible debentures. So convertible, just before I leave I come to convertible. Now, just as we have perpetual debentures, then certainly we have a redeemable debenture. So that one is no point because debenture conceptually is supposed to be redeemable, except that it can be structured in such a way for it to appear to be irredeemable. And that is why we have the concept of perpetual debentures. Now, we also have convertible debentures. Convertible debentures, in terms of Section 88, may be issued on the terms that in lieu of redemption or repayment, the debentures may, at the option of the holder or the company, be converted into shares in the company on the terms that are stated in the debentures. So you are a debenture holder. Terms have been stated, and the terms include the fact that at certain future date or under certain condition, you, the debenture holder or the company, may choose to have the debenture be converted or be changed from being a debt to become part of the loan capital or the equity. So when it happens that way, then the debenture holder becomes a shareholder. So that is it. Now we also have secured or unsecured debentures. So debentures may be secured by a charge over the property of the company or may be unsecured by a charge. And in fact, when it comes to discussion of debentures, it is this particular aspect which takes greater part of the discussion, that is secured and then unsecured debentures. Just a second, I've seen my dog has come to stand at the part of the camera where it wants me to see it in the video. Just a second. Cindy? Cindy? Sorry, sometimes it can be amazing how some of these creatures can have impressive level of intelligence. Anyway. Yeah, so I was making the point that debentures may be secured or unsecured. If it is uh, secured, that is to say that it's secured by a charge. If it is unsecured, meaning that there's no charge relating to that. So the question is, what is a charge? When we say a charge, what is it? So we will go to the definition section to look at the definition of a charge before we continue with looking at the various types of charges. So just go to page 302. And so we look at your law. So notice, see. So as you can see, where I've used a blue to circle. So that is like a charge. Charge includes a security on property or a mortgage, whether legal or equitable statement to the effect that it is a true and complete copy of the original or an accurate translation of the original under the seal of the company or signed by the director and the company secretary. So if you have a security on assets or property of the company, or if you have like a mortgage, be it a legal or equitable mortgage, that is an example of a charge. So let us keep that in mind. But there's something I will show you before we move on. Where's the eraser? just want to show you. Trying to get the example of a certain instrument to show you, but it's not readily available. So later on, I will retrieve it and post it on your platform for you to see practically how it is. Yeah, so we just made the point discussing section 89 that to start with, we have another type of debentures referable to whether it is secured or not secured. So we have secured debentures and unsecured debentures. Unsecured debentures is also known as a naked debentures. So when we say naked, naked means that the debenture is not protected by any security. And in terms of secured debentures, there are two types. Secured debenture may relate to a fixed charge or a floating charge. So if you look at section 89(2), the debentures may be secured by a fixed charge on some property of the company. So a fixed charge means that a particular property of the company or particular set of assets of the company which have been used as the security. And that was if it's a fixed charge, specific property of the company, which has been used to create a security for the lender regarding the money that has given the company by way of the debenture. Then we also have a floating charge. So floating charge over the whole or a specified part of the undertaking and assets of the company, or by both a fixed charge on the property and a floating charge. So with respect to floating charge, it is security all right. However, the security created does not apply to a specific property of the company, but over a class of properties or particular aspect of the undertaking or operations of the company. And what that means is that the security created by the floating charge has not yet settled or fastened or become concrete with respect to a particular property of the company. That we can say that this property is my security for the loan or for the debenture that I have in the company. No. Certain things will have to happen in future before the floating charge will settle on specified property. So unlike a fixed charge, where right from the creation, we know the particular property over which you have security, so that if anything goes wrong regarding repayment terms and so on, you can always take the necessary steps to protect your interests, either by even taking steps to get the sold or some put under receivership or anything like that. So that is the fixed charge. But the floating charge, as we have indicated, there's no particular property, but stated events may have to occur before the charge will become enforceable over, maybe then it will then settle on the particular set of properties of the company. So let us keep that in mind. Now, there has been a lot of debates in the literature, in particular the case law, regarding the nature of floating charge, regarding the legal character of a floating charge. So I will take you to some of the old cases, and then we will simplify it by looking at the current thinking, as in the English decision in the Ray Spectrum Plus. But before that, in old cases like Ray Yorkshire Cumbers Association Limited, a case which is known to every student of a company law. So if you are students of company law, I'm sure you too would like to know it. So Ray Cumbers Association Limited. Um, 1903 to Chancellor 284. Yeah, so a Ray, so I think I get the Ray Yorkshire Cumbers, the Yorkshire didn't come. Yorkshire. So in Ray Yorkshire Cumbers Association, the point was made by Lord Justice Roma that, quote, floating charge is not a legal term. It has recently been used in more than one statute. But when the courts have to consider whether the charge is a floating one within the meaning of the term, as used in the Acts of Parliament, and in particular, within the meaning of the Companies Act 1900, which provides for registration of charges, one must, I think, deal with the question of substance to be answered, according to the circumstances of each particular case. I certainly do not intend to attempt to give an exact definition of the term floating charge, nor am I prepared to say that there will not be a floating charge within the meaning of the Act, which does not contain all the three characteristics that I am about to mention, and that's what I want us to pay attention to. So, Lord Justice Roman speaking. Which I'm about to mention is a floating charge. One, if it is a charge on a class of assets of a company, present and future. So a class on the, it's a charge on the class of assets of the company, present and future. Assets that the company has now or the assets that may acquire in future. 2, if that class is one which in the ordinary course of the business of the company will be changing from time to time. So the floating charge may be over a class of assets which do not remain the same. They're being changed here and then. Let's take the stocks of a merchandise, like maybe the stocks of a shop, as it were, or even like the raw materials in the company, factory, production plant. The raw materials are changing because they'll be consumed in the production process, another set will come and so on. Or even the final products in the warehouse, they also don't remain standstill because after the production line, they are put in the warehouse. Now the supply will be done. So they will go, they'll become empty. Another that production is done, and then they are replenished. So that is also possible to have the charge over those assets, which in the ordinary course of business of the company will be changing from time to time. And 3, if you find that by the charge, it is contemplated that until some further step is taken by or on behalf of those interested in the charge, the company may carry on its business in the ordinary way as far as concerns the particular class of assets I am dealing with. Yeah, so His Lordship was making the point that if that is the situation, then we are talking about the floating charge because certain things will have to occur in future or certain things will have to be done before the security created by it will be biting, because it will really be binding. Because if you take a fixed charge, for example, a fixed charge, the assets over which the fixed charge is created cannot be dealt with by the company anyhow. The company will need the permission of the charge holder. If the company, for example, wants to use it for any other thing or even dispose of it or any other thing, because there's encumbrance on it, it is incumbent. So let's keep that in mind. And of course, and that is why in the similar related case, Ellensworth and Hosworth, Lord Magneton also gave a very interesting definition. Let me bring this here. So let me put it here. Ellenworth. Yeah, so in Ellenworth and Hosworth, Lord Magneton also made the following observation as far as a floating charge is concerned. I quote, "What I said was intended as a description, not as a definition of a floating charge. I should have thought there was not much difficulty in defining a floating charge. What a floating charge is in contrast to what is called a specific charge. I think is one that without more fastens on ascertained and definite property, capable of being ascertained and defined. A floating charge, on the other hand, is ambulatory and shifting in its nature, hovering over and, so to speak, floating with the property which it is intended to affect until some event occurs or some act is done which causes it to settle and fasten on the subject of the charge within its reach and grasp, unquote. So that is a floating charge. So for that matter, one would say that floating charge is, if you like, ambulatory. It's hovering over assets until something has occurred in future or certain steps have been taken before it will fix onto or become fastened onto particular assets. So let's keep that in mind. So having noted that, let's look at the law. But just before we look at the section 90, subsection 2 particularly, I would like us to also appreciate the fact that in the position of the law has now been clarified by relatively recent decision of the UK House of Lords, or now the Supreme Court, in the Ray Spectrum Plus Limited, the case under the Brumac investment. Let me give you the title. So Ray Spectrum Plus. Ray Spectrum Plus. Two 2005. So in Ray Spectrum Plus Limited, Lord Scott of First Court, or for example, make the observation that, quote, the essential feature of a floating charge, the characteristic that distinguishes it from a fixed charge, is that the asset subject to the charge is not finally appropriated as a security for the payment of the debt until the occurrence of some future event. In the meantime, the charge is left free to the charger, that is the charge holder, is left free, no, not the charge holder, the company. The charger is left free to use the charge asset and remove it from the security, unquote. So ultimately, what the court was saying is that the bottom line, in terms of distinction between floating charge and a fixed charge, has to do with the autonomy or the freedom which the company has over the subject property, which constitute like the security. Whereas in the case of a fixed charge, the company does not have any freedom, any autonomy to deal with it as it chooses, and it will have to have recourse to the charge holder. In the case of a floating charge, the company has that latitude or that autonomy to deal with the charge property as it wants until the security has become enforceable, in which case the company will now lose the freedom to deal with the charge property in ordinary course of business as it chooses. So having said that, we will now look at section 92, which says that a floating charge who says that a floating charge does not preclude the company from dealing with the assets of the company. So that the point that was made in the risk spectrum class, until A, the security becomes enforceable and the holder of the security, pursuant to a power in their behalf in a debenture or the deed securing same, appoint a receiver or manager or enters into possession of those assets. B, the court appoints a receiver or manager of the assets on the application of the holder. Or C, the company goes into liquidation. So when any of the following those instances have occurred, then the charge is said to have become crystallized. The charge crystallizes and becomes a fixed equitable charge on those assets of the assets of the company that are subject to the charge. So when any of the events stipulated in 92, either something is stated in the document creating that charge, that when this situation arises, then the charge holder can appoint a receiver or a manager to enter into possession of those assets or to take over the management of the company regarding those aspects and be collecting the revenue coming to the company with the view of either applying them to pay the debt owed to the debenture holder, or the court appoints a receiver or manager on application of the holder, or the company goes into liquidation. At that stage, of course, when a liquidator is appointed, the company will not be able to deal with its even assets and the whole of its operations as a business as usual. It cannot do that in the ordinary course of business because liquidation will have kicked in. So when any of these things have occurred, then the security will now become biting because it will now fasten onto identifiable assets of the company. Now, it is possible where a receiver or manager has been appointed to take over the undertaking of the company or the company with respect to the assets, which constitute like the chart, the floating chart, as it were. When things improve, when the company becomes financially healthy and things are stable, the chart holder may, for example, withdraw the receiver or the manager so that the company will be put on its usual operational footing. Now, in terms of priority, and that is the crucial aspect when it comes to security. Because why do people want security? People want security in the sense that when things become horrible and then the company is collapsing, the assets are generally not enough to be able to satisfy all claims. So some lenders, some creditors, particularly secured debenture holders, may want to be given priority, may want to be put ahead in the queue, ahead of other claimants for the assets of the company, which are generally not enough because the company is actually struggling to survive. So therefore, Section 92 says, Section 5 says that a fixed charge on a property has priority over a floating charge affecting that property, unless the terms on which the floating charge was granted prohibited the company from granting a later charge having priority over the floating charge, and the person in whose favor that later charge was granted had actual notice of that prohibition at the time when the charge was granted to that person. So 95 is saying that as a general rule, where you have a fixed charge and a floating charge over assets of the company, then the first charge will be ahead in the queue or will have priority when it comes to payment, particularly so when things are not going on well with the company, and the company is, for example, being liquidated or as it were. The exception to that general position of the law is that where a floating charge has been created over maybe class of properties, as it were, and there is a clause in the instrument or document creating the floating charge to the effect that the company does not have the right to create any charge which will rank superior to this particular floating charge, then in that case, if the company should go ahead and create a subsequent charge, such as a fixed charge. Now, if the fixed charge holder was very much aware that there was a pre-existing floating charge with respect to the properties of the company, then despite the fact that, ordinarily speaking, a fixed charge holder will have had priority or have been ahead in the queue, this fixed charge holder will not enjoy the priority status, and it will rather be subordinated to the floating charge. And the floating charge will rank first because of that, what we call the negative pledge clause, because of the clause in it that the company should not create any subsequent charge which will rank superior to it. So let us keep that in mind. It's 8:53, so we will draw the curtain down here and continue at our next class. What will happen is that tomorrow in the evening, and then almost around tomorrow at 7:30, hopefully, we'll do 1 hour, and that will be jurisprudence. And then Thursday we'll meet and do both company law and jurisprudence. Okay, so have a good night.